Okay, part 3 of chapter 7, the role of counsel, is counsel conflicts of interest. As the Strickland Court notes, in certain Sixth Amendment contexts, prejudice is presumed. United States v. Cronick, 1984, cited in this connection, provides a more complete description of the instances of per se Sixth Amendment violations. At issue in Cronick, which was decided the same day as Strickland, was a lower court ruling that found a Sixth Amendment violation without examining the actual performance of defense counsel. The lower court had held that a combination of circumstances required the inference that counsel would have been unable to provide effective assistance required by the Sixth Amendment. Those circumstances were 1, 2, 3, 4, 5. First being the limited time afforded counsel for investigation and preparation. 2, counsel's inexperience. 3, the gravity of the charge. 4, the complexity of possible defenses. And 5, the inaccessibility of witnesses to counsel. Rejecting lower court's inherent ineffectiveness rationale, the Cronick Court stressed that the underlying function of the Sixth Amendment required an analysis of whether there had been an actual breakdown of the adversary process due to the counsel's deficient performance. The 5 factors cited by the lower court, though of obvious relevance in the evaluation of a lawyer's ineffectiveness in a particular case, were not sufficient to establish inherent ineffectiveness. Okay, so that was rejected. Five factors to show inherent ineffectiveness, which I want to say absent performance claim. So, 5 factors cited by the lower court, though of obvious relevance in the evaluation of the lawyer's ineffectiveness in a particular case, were not sufficient to establish inherent effectiveness. The court acknowledged that it had recognized in the past certain special settings in which a presumption of prejudicial defective performance had been adopted, but refused to expand upon those situations. In a discussion that was partially repeated in Strickland, Cronick identified 3 settings in which the court previously has been willing to presume a breakdown of the adversary process. First, there was a situation in which counsel was either totally absent or prevented from assisting the accused during a critical stage of the proceeding. Falling in this category were cases in which the trial court had unconstitutionally refused to appoint counsel or had restricted counsel's assistance. The second situation was that on which counsel was physically present but completely absent in effort. As the court put it, if counsel entirely fails to subject the prosecution's case to meaningful adversarial testing, then there has been a denial of Sixth Amendment rights that makes the adversary process itself presumptively unreliable. And you see that that's in the footnotes coming from Bell v. Cohn in 2002, later held that this situation is presented only where counsel's failure is complete and not where the counsel simply failed to take particular steps, important though they might well be, in challenging the prosecutor's case. Thus, the federal habeas court had erred in presuming prejudice as to a capital sentencing proceeding because counsel failed to introduce mitigating evidence and waived closing argument. Since counsel had challenged the state's case in other respects, including bringing out favorable evidence on cross-examination of the state's witnesses and calling the jury's attention to an opening statement to mitigating evidence that had been introduced as part of an insanity defense, the allegation as to not presenting mitigating evidence and waiving closing argument constituted no more than claims of specific attorney error, which were subject to Strickland standards. So, footnote A was the cases in the latter category have been described as the state inference cases. The leading inference case is Getters versus U.S. as described in Strickland. And that footnote correlates to can't tell what that correlates to on the page. So, nonetheless, finally, there were occasions when, although counsel is absent to assist the accused during trial, the likelihood that any lawyer, even a fully competent one, could provide effective assistance is so small that a presumption of prejudice is appropriate without inquiry into the actual conduct of the trial. Crim described Powell versus Alabama as such a case. The trial court there had ordered newly arrived out-of-state counsel to proceed immediately to trial with whatever help the local bar appointed en masse might provide, even though that counsel had stated that he had no opportunity to prepare and was not familiar with local procedure. Both Strickland and Cronick acknowledged still another line of cases that established an exception to Strickland. The conflict of interest case is a potential conflict typically arises where defense counsel owes an obligation to a person other than the defendant that could favor action or inaction adverse to the interests of the defendant. So I think this is coming into the conflict of interest section. There's actually a footnote here. While conflicts most often arise from an obligation of loyalty owed to a past or current client of the defense counsel, a conflict can also exist because the attorney has a self-interest that could lead to action or inaction adverse to the client. The self-interest will often be economic, as where the attorney's fee being paid be a person other than the defendant, and that person's objectives may diverge from the defendant's interests, but it cannot also be personal, as well as where the defense counsel was involved in the same transaction as the defendant and has the interest in not revealing their participation. So this was described as more limited presumption of prejudice arises on judicial review after conviction, where the defense argues, often for the first time, that defense counsel was subject to a conflict of interest. The first case in this section, Mickens v. Taylor, presents the leading Supreme Court discussion of this presumption. Mickens also includes the leading discussion of 1, the limited constitutional obligation of the trial court to inquire into the possibility of a conflict in its own initiative, and 2, the constitutionality required response of the trial court to a defense counsel's motion to withdraw, which alleges a conflict of interest. Mickens is the next case, and so that's what Mickens discusses, the limited constitutional obligation of the trial court to inquire on its own initiative, and the constitutionally required response of the trial court if the defense counsel motions to withdraw, alleging a conflict of interest. In the second case in this section, United States v. Wheat, also alleges also relates to alleged conflicts of interest and the response of the trial court. Here, however, the issue before the Supreme Court is not what the trial constitutionally must do to protect the defendant's Sixth Amendment right to effective assistance, but the limits on what the trial court may do. The pretrial objection to the conflict in Wheat is presented by the prosecution, and the defense opposes the relief proposed by the prosecution, disqualifying defendant's proposed counsel. The constitutional issue here is whether the disqualification violated the defendant's Sixth Amendment right to counsel of his own choosing. The issue arises not where the prosecution seeks disqualification, as in Wheat, but also when the trial court considers disqualification after conducting inquiry on its own initiative, as discussed in Mickens. So Mickens is here on page 934. going to page through that. We're going to page through Wheat to part 4 because the professor didn't require reading this section. So the next subpart of Chapter 17 is counsel control versus client control. I'm going to read this short introduction before Florida v. Nixon. And you also have to read Section 5, which is the right of self-representation. So if there's time, we'll get to that too. So as discussed previously, absent a Strickland violation, clients typically are bound by the actions and inactions of counsel. The Supreme Court has long recognized, however, that the decision to exercise or relinquish certain procedural rights is personal to the defendant. Here, the client must be consulted and the client's wishes must control. Prior to the ruling in Florida v. Nixon, the Supreme Court had stated in dictum or holding that it was for the defendant to decide whether to take each of the following steps. 1, plead guilty or take the action. So prior to Nixon, client control was 1, plead guilty or take action tantamount to entering a guilty plea. 2, waive the right to be tried by the jury, thereby accepting a bench trial. 3, waive the right to be present at trial. 4, waive the right to testify on his or her own behalf. And 5, forego an appeal. So these should really be written down. On the other hand, the court had indicated in dictum or holding that counsel had ultimate authority in deciding whether to exercise a large group of procedural rights, and counsel's strategic decision here was controlling absent a Strickland violation. The leading ruling on this distinction was Jones versus Barnes of 1983, where the court rejected a contention that the appointed appellate counsel, so weird, on a first appeal of right, had violated Strickland by refusing to include in the appeal, in the appellate brief, an arguable claim that defendant desired to press. The accused had the ultimate authority as to the decision as to whether to appeal, but the determination as to what contentions to include in the appeal was strategic and for counsel to determine. Counsel traditionally have been free, the Jones court noted, to follow the time-tested advice that a brief that raises every colorable issue runs the risk of burying good arguments. Where the defendant's personal choices does control, counsel's failure to abide by a defendant's directive may present another instance of per se ineffective assistance of counsel. So that's big. This was in the Jones court, Jones versus Barnes, saying that where the defendant's personal choice does control, counsel's failure to abide by the defendant's directive may present another instance of per se ineffective assistance of counsel. Thus, where the defendant directed trial counsel to pursue an appeal and counsel failed to do so, that failure constituted professionally unreasonable performance that created automatic prejudice under chronic, the denial of the entire judicial proceeding being even more serious than the situation cited in chronic as demanding a presumption of prejudice. Roe versus Flores Ortega, 2000, in Florida v. Nixon, the state court had relied on this disobeyed directive analysis to conclude that counsel there in proceeding without the client's consent rendered per se ineffective assistance under the chronic standard. Though the court in Nixon clearly rejects that analysis, all right, so looks like Nixon didn't agree with chronic. The lower courts recognized that the implications of that rejection are far from clear, both as to what, if anything, the rejection suggests about the character and personal choice decisions and what is suggests as to counsel's general obligation to consult with the defendant. Right. So, Florida v. Nixon, I think, is the only case in that section, and we're going to fly to section 5. And just read that intro, because I'm going to brief Florida v. Nixon separate from this reading. So, the right of self-representation is section 5, and it begins introducing Ferretta v. California, which is the only case that we're going to examine in that section. Ferretta v. California established a constitutional right to self-representation. That's what it stands for. I.e. the defendant's right to proceed pro se. Although later cases, as discussed below, have added refinements to the scope of the right, Ferretta remains the primary source for defining that right in the context of a defendant who seeks to represent himself at trial. Prior to Ferretta, several state appellate courts recognized a broad discretion of trial courts to insist that defendant be represented by counsel. In reaching this result, they rejected the contention that either state law or the federal constitution law established a constitutional right to self-representation. These rulings arose in two quite distinct procedural settings. In some instances, the defendant, fully informed of his right to counsel, including appointed counsel if the defendant was indigent, expressed a desire to proceed pro se, and the trial court responded that the defendant would not be allowed to do so if he went to trial, in contrast to entering a guilty plea without counsel, which would be acceptable with a proper waiver of right to counsel. In others, the defendant did not initially seek to proceed pro se, but to replace his current counsel. However, after the trial court refused to allow replacement, he then asked to proceed pro se, with the trial court rejecting that request and insisting that the defendant continue with his current counsel. Here, the initial issue for the appellate court was whether the refusal to allow replacement was proper under governing standards, but if the trial court had ruled correctly on that point, the appellate court then had to decide whether the trial court had the discretion to refuse to allow the alternative of self-representation. Ferretta presented a situation in which the defendant initially sought self-representation, but the Sixth Amendment right it recognized would similarly be available to a defendant who preferred a different counsel, but clearly chose self-representation when replacement was denied. Indeed, a substantial portion of the large body of lower court rulings interpreting Ferretta have involved assertions of the right to self-representation after the defendant's request for replacing counsel was denied. Challenges to convictions based on Ferretta have come both from defendants who were denied self-representation and defendants who were granted self-representation. Those denied self-representation argue that the denial was not justified under Ferretta. Those granted self-representation typically argue that they were not sufficiently informed of the dangers of self-representation as required by Ferretta. And therefore, the waiver, so that's going to be an analysis. These analyses are going to be addressed in Ferretta. Therefore, the waiver of the right to counsel was invalid. Although the leading Supreme Court case presenting a challenge by the defendant granted self-representation involved a claim that the actions of standby counsel undercut the defendant's Ferretta right. Such claims have been far less common. In 3 key post-Ferretta rulings, the Supreme Court re-examined the grounding of Ferretta and concluded that in each case that an aspect of Ferretta should not be extended to a procedural setting held distinguishable from that presented in Ferretta. So, a couple things no longer stand in Martinez. In Martinez, there's the Court of Appeal of California, 2000. The court distinguished Ferretta as to history and relevant constitutional structure, and holding that there was no constitutional right to self-representation in the appellate process, and the state judiciary therefore could insist the argument on appeal be presented by counsel. In Iowa v. Tovar, 2004, the court rejected the lower court's extension of Ferretta's requirement that defendant be made aware of the dangers and disadvantages of self-representation. So the warnings got lowered. Such a warning was not required constitutionally for a defendant's waiver of the right to be represented by counsel in the course of entering a guilty plea. The extent of the warnings required varied with the procedural setting, and as the court had noted in a pretrial context, less vigorous warnings are satisfactory when the full dangers and disadvantages of representation are less substantial and more obvious to the accused than they are at trial. And then third, Edwards versus Indiana in 2008 provides the most recent and the arguably most significant reexamination for Ferretta. In Martinez Supra, 2 concurring justices viewed the majority opinion as casting doubt upon the rationale of Ferretta. And Justice Breyer's concurring opinion took note in lower court that expressed dismay about the practical consequences of Ferretta. The Edwards court, however, in an opinion by Justice Breyer, flatly rejected Indiana's request that the court overrule Ferretta. Breyer's opinion acknowledged the concern that Ferretta had led to trials that are unfair, but noted that recent empirical research suggests that such instances are not common. Moreover, those instances may well be concentrated in the 20% or so of self-representation cases where the mental competence of a defendant is also at issue. And the court's ruling in Edwards, Breyer noted, would grant trial judges the authority to deal appropriately with such cases. In Edwards, the majority rejected a lower court ruling which read Ferretta and a later Supreme Court ruling as holding that once a defendant is determined to be competent to stand trial, his mental illness becomes irrelevant, and only issue is whether he has an understanding of disadvantages of proceeding pro se required by Ferretta. The court held that the presence of mental illness distinguished Ferretta, and that the Constitution permits states to insist upon representation by counsel for those defendants competent enough to stand trial, but who still suffer mental illness to a point where they are not competent to conduct trial proceedings by themselves. The court stressed the trial judge's capacity to make fine-tuned mental capacity decisions tailored to the individualized circumstances of the particular defendant. It left open, however, the possible adoption in the future of a specific standard as to the measure of the defendant's ability to conduct a trial, finding no need at this point to rule in the state's suggestion that would deny a criminal defendant the right to represent himself at trial where the defendant cannot communicate coherently with the court or jury. And I skipped a couple of footnotes that talk about McCassell versus Wiggins. In 1984, the standby counsel had gone beyond the traditional role of steering a defendant through the basic procedures of a trial, engaging in arguably unsolicited participation on various substantive matters. In part, this was due to confusion created by the defendant's frequently shifting position on the assistance he desired from counsel. While citing this factor, the court also reasoned that unsolicited participation exceeding bypass counsel's appropriate role did not undercut defendant's Ferretta right where, 1, it did not interfere with the defendant's own actions in such a way to deprive him of actual control over the case he chose to present to the jury, and 2, did not destroy the jury's perception that the defendant was representing himself. So there's such thing as standby counsel, and this was the reasoning. 2 factors. And the Tovar court, which I want to say is this Iowa versus Tovar, offered the following description as to what required the context of the defendant seeking to proceed pro se and entering guilty plea. The constitutional requirement is satisfied when the trial court informs the accused of the nature of the charges against him, of his right to be counseled regarding a plea, and of the range of allowable punishments attendant upon the entry of a guilty plea. Our past decisions have not prescribed any formulary script to be read to a defendant who states that he elects to proceed without counsel. The information a defendant must possess in order to make an intelligent election will depend on the range of case-specific factors, including the defendant's education and sophistication, and and the complex or easily grasped nature of the charge and the stage of the proceedings. The constitutional test for competency to stand trial, as summarized in Edwards, has two prongs. So, prong number one, whether the defendant has a rational as well as factual understanding of the proceedings against him, and two, whether the defendant has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding. In Godinez v. Moran, 1993, the court rejected the contention that a more rigorous competency standard was required when the defendant was proceeding per se, whether entering a guilty plea or going to trial. While the competency standard was developed in the context of the defendant represented by counsel, the standards required mental capacity, encompassed rational understanding of a variety of personal choices. There was no reason to believe that the decision to waive counsel requires an appreciably higher level of mental functioning than the decision to waive other constitutional rights. The court also warned, however, that the presence of competency did not relieve the trial court of the obligation to determine that the defendant has a necessary understanding for the waiver. The competency standard addresses only the potential ability to understand the proceeding, not whether the defendant does understand. In Edwards, the trial court had found both that their defendant was competent to stand trial and that he had the understanding required by Ferretta. The state appellate court held that, in light of those findings, the Ferretta and Godinez trial had lacked the authority to deny self-representation, and it had done on the ground that, with obvious continued schizophrenia, defendant was not competent to defend himself. Okay, so that's basically the introduction of each of the subparts of Chapter 17, which is the role of counsel.